Today I want to talk to you about trademarked, patent, and copyright. I just want to kind of make sure that you understand what the differences are. So a copyright, you're going to have a protection pretty much automatically. If you write something, if you create something, anything that you did physically, that you did by yourself, or with assistance of a program, such as Canva, Corel, Photoshop, anything along those lines, that is automatically copyrighted. A trademark, however, is something that you have to apply for. And what the important thing to understand about trademarks is that it protects the name, and it's for specific things. So if you have a trademark and your trademark is, we'll take mine for example. So hardworking mom. So I have a trademark on hardworking mom, and it protects specific things that I have outlined in my trademark. So it's going to protect products, t-shirts, signs, coffee mugs, tumblers, anything like that that has the phrase hardworking mom on it. So I have just a general trademark on that phrase. So you really need to make sure, if you are making digital products or selling physical products, that you are checking to make sure you're not violating someone's trademark. Just because you've heard a phrase or you've come up with a phrase doesn't mean you have the right to use it. So make sure you are checking. Some things we kind of automatically know, right? Like, you wouldn't want to use Mickey Mouse on something because it is a trademark. And just because you've gotten away with using it once doesn't mean you're going to be able to do that again. These companies, they protect their trademarks and they protect them fiercely. So don't get yourself in trouble with that. Okay, so now let's talk about a patent. A patent is something that is a protected process, essentially. If you made a picture frame and you made it in a special way that helps, it's useful or something like that, you can apply for a patent. The patent protects people from stealing your idea and using it over and over. Patents, like trademarks, are for specific types of things, right? So if you have a patent, it's for the specific thing that's written out in the patent. So if you see someone online who has made something, let's say the mesh roller. If you see the mesh roller online and it says patent on it, don't do the same thing and sell it, because you can be sued by the person who owns the patent. And it is not a good thing because you can't defend it, and it would cost a lot of money, and you would have to give them all of your sales that you just used on that item. So make sure you understand what you're doing, how you're doing it, so that you don't get yourself in trouble. Because when it comes to any regulations, guidelines, or laws, not knowing them is not a defense. So ignorance is never a defense if you are getting yourself in trouble with copyrights, trademarks, or patents. So just be careful.